Well, welcome back to Judicial Ways of Working, the podcast series produced by the Institute of Advanced Legal Studies at the University of London. My name is Carl Stychin, and I'm the director of the Institute. This series explores how members of the judiciary are working during the global coronavirus pandemic. I'm delighted to welcome the Honorable Judge Mark E. Hood to today's podcast. Judge Hood is a Superior Court judge in Monterey County, California, where he is currently assigned to the felony criminal assignment. With 22 judicial officers and a population of 500,000, Monterey County is considered to be a moderate-sized county in California. Judge Hood is a graduate of San Francisco State University, and he earned his law degree from McGeorge School of Law in California. Prior to being elected to the Superior Court, Judge Hood was a prosecutor for Santa Clara County for 20 years. He began his career as a civil litigator in San Francisco. And welcome to the podcast, Mark.
Well, thank you very much. It's good to be here.
Could you describe, just to give us some context, what your everyday professional life was like before the pandemic? What was your routine as a judge?
Well, right now I'm currently assigned to the criminal felony division. Here, felonies are what we'd consider major crimes, any situation where the accused is facing multiple years in custody, whether local custody or state prison. In Monterey County, we do what's called a vertical assignment. So once an individual is arrested and initially charged with the offense, then we get that case. I'll get a series of cases. We break it down by alpha, so I have the letters. Anybody with the last name R, beginning with R all the way to Z, they all come to me, and then I stick with the case from day one all the way to the conclusion of the case. My days are Tuesdays and Thursdays are what we call court days. Have approximately about 150 matters on Tuesdays and Thursdays for various hearings, motions, discussions, events. And then Mondays, Wednesdays, Fridays, conduct jury trials, court trials, and other matters.
And prior to the pandemic, to what extent was your judicial role enabled by technology? How technologically engaged was your court?
Well, fortunately, Monterey County is essentially has been an early adopter, well, relatively early adopter. In 2017, we went to a modern case management system for both civil and criminal across the board. Early on in the adoption of the modern case management system, we chose to go live paperless from day one. Many courts choose to go paper and non-paper, and we find, and we've learned that those courts are years behind. So literally day one, we went paperless, electronic filing in civil, followed sometime later by criminal. Our files disappeared each and every day. And on the day one where we went live, we had no paper. And we were in line with our laptops and desktops on the desk. Many of the things we do here are electronic, not just the court cases. Meeting with officers for search warrants, they would come in and meet with us. That's now electronic. Probable cause meetings, the officers would often come to our homes on nights and weekends, present the case, whether an individual could be held for 72 hours or not, or more than 72 hours. Again, that is electronic. So fortunately, we were quite modern at the time. There's always more to do, but we are a full electronic court, and that has served us well in this recent crisis.
It sounds that would prepare the court very well. So what then had to change as a result of the pandemic, and how was that managed?
Well, it was quite an initial ordeal. We saw what was coming. But California closed down rather quickly with Governor Newsom shutting down the court with the stay-at-home orders. So although we were beginning to prepare, it was rather abrupt to the point where everything's fine one day, and that afternoon we are advised we're closing the courthouse, we're continuing all matters. All county attorneys, that would be the prosecutors, the public defenders, will no longer be permitted to come to court. They won't be permitted to be in their offices. And so the initial 48 hours was a true scramble. What do we do? How do we handle the cases? How do we handle emergency matters? We had two major trials going on. What do we do in that situation? So we adapted quickly. The very next day, we had staff outside the courthouse giving people their new dates. So many date cases were just continued for 1 to 2 months. Time-sensitive cases were continued a shorter time. Our Chief Justice provided emergency orders so we can continue matters past the normal cutoff dates. And then we started to decide how we were going to proceed. So the first step was the emergency. We have 24 hours, 48 hours to get together. And then probably the best thing we did was set up meetings with all of our justice partner agencies, the counties, the attorneys, law enforcement agencies, anybody that the courts deal with. We essentially had daily meetings, representatives from each. What are the issues? What's the issues as the county jail facing? And then those, at the end of those meetings, briefings would go out, and those would go out to every judge. So every judge could see the daily briefing. And then we began to have online courts with GoToMeetings. We have a rather large and well-adept IT department, and they set us up with, we tried Microsoft Teams, GoToMeetings, ended up with GoToMeetings for ease of use for others. And within 48 hours, we were doing emergency hearings, all electronic. Inmates would be in the county jail appearing electronically. Attorneys would be at their homes appearing electronically. The judge, however, does have to be in court, cannot hold a court hearing from their home or from their office. So for formal court hearings, at this point, the judge is in the courtroom, still wearing their robe. A judge here in California cannot conduct any official business unless wearing their robe. So what would happen is we'd be in the courtroom. The deputy would be there because the deputy or bailiff would have to be there because the judge is in the courtroom. A court reporter could be in the courtroom, could be in her home, or could be in chambers in their office, recording, taking a record electronically. The interpreters we do have a lot of interpreters in our county. They could appear in court or appear electronically from their office or home and translate electronically. And oftentimes it would be just the judge and maybe 1 or 2 staff members in a courtroom. Occasionally somebody would be allowed in the courtroom, a defendant wearing a mask, and we would display the entire proceedings in the courtroom on a large screen. So we would have an overhead projector in the courtroom that would display the GoToMeeting. Everybody would be logged in, and we would conduct our normal sessions. And it was lots of trials and errors and missteps. And has the jail got the best equipment? Are the phone lines working? Does the attorney have the passcode to log in properly? And probably, again, the best thing we did was each judge, and we would rotate judges in because most were at home. Each judge at the end of the day would give an update. This is what the issues were. This is how we resolved the problems. And that would go out to each judge in the county. And then the justice partners would have their meetings. So every day we had meetings, every day we had debriefings, and every morning the next day, the person went off with the new information. So that is probably the best thing we did, was to have the daily meetings and the debriefings.
Well, it sounds like that you were quite well prepared for judging at a distance. But are there aspects that you find and have found particularly challenging to this new way of working?
Oh, absolutely. We do have quite a bit of volume. And my normal week would be on a Tuesday and Thursday, easily hear 150 matters. Sometimes have 75 matters in a morning. Once we went online, it was excruciatingly slow. Interpreters could not interpret simultaneously. You would have to speak, The interpreter would interpret, and it would slow things down dramatically. We also found we just couldn't go as quick as possible, as quick as necessary. And what I could normally do in 75 matters, I could only do 20 matters. So luckily we did have reduced calendars because of necessity of continuing cases, but it was just much slower in the process. And some of it was due to technology, some of it was due to non-simultaneous interpretation, and some of it was due to just the people getting used to the way to proceed.
And by contrast, are there aspects that you found that you quite like, that you prefer in terms of remote working?
Well, I think it's allowed me to have more, when I would have informal discussions with the attorneys, it's on a set time, set schedule, and set protocol for even for informal discussions. Once we went to this truly online court, essentially, we made ourselves available to the attorneys. Anytime you have your client available, anytime the two parties have an issue, instead of waiting for a scheduled date, they could contact our clerks. We would schedule an instant online meeting or schedule it for a half hour later, an hour later. And I found it much more effective and efficient to be there and be available when the parties reach an agreement. Having a delay of even 2 or 3 days can often change things. But if the judge is available and can say, let's meet, let's discuss, let's resolve the issues, then I found that very effective. Also found that it was nice when somebody has to appear in court. Unfortunately, it's usually at a minimum of half a day. Even though their appearance may be only for 15 minutes, they're there a half a day waiting for their turn. Now with online, they could appear electronically, they could be at home or even take a break from their job. They're now 15 minutes of their time is taken up. They're not taken away from work. They're not traveling. They're not having the expense of travel. And some of our people are easily 100 miles away from the courthouse. All of a sudden, their half a day or 3 days time spent to appear in court are now down to 15 minutes. So it really increases access to the courts. That is what I found is the most beneficial.
And that's a benefit. I wonder if there are particular causes of concern that you have regarding justice issues.
Well, I think my biggest cause of concern, and we're starting to see it as we conduct more evidentiary hearings, is when you're in jury trial or having an evidentiary hearing, such as we call a preliminary hearing, a probable cause determination of whether the individual should be held on the charges, we're listening to witnesses and we're evaluating their credibility, and the jury is evaluating their credibility. And we evaluate credibility not just based upon words, but based upon mannerisms, based upon eye contact, based upon intonation, based upon physical movement, based upon interaction between the witness and the attorney. Those you can't see and truly feel online. Those you can't see through a mask. The intonations, it's online, it can be so mechanical. So my biggest concern is for any evidentiary hearing where the witness is critical, that it not be online, that it be in court. Now we've started to install plexiglass around the witness stand, and we're going to establish how we're just finalizing the rules on jury trials, how a witness is going to testify in a courtroom. So they'll still be on the witness stand. They will have now plexiglass around them. We have been debating the use of masks because now everybody in the courthouse must wear a mask. I'm not wearing one right now because I'm in my chambers and the door is closed. And as one attorney we discussed yesterday, I have a major trial coming up in this case. It's a 2 to 3 week long trial. The victims are child victims, and the prosecuting attorney indicated that even though she has priority to go to trial because of the nature of the charges, she is not comfortable proceeding to trial unless her witnesses can be seen by the jury. And if I'm going to order that they must wear masks, then for that, she's going to say, that's good cause to continue my hearing. The jury can't see them. The jury can't feel their true testimony, and therefore we need a continuance. So I think that is my biggest concern for electronic matters, is if you have an evidentiary hearing with credibility is an issue, then it truly cannot be done online.
So assuming that we're now very gradually going back to some form of normal, what's sometimes referred to as a new normal, um, do you think there are clear lessons that can be learned from this time as to how we resolve cases in the future? And I'm really wondering about what this experiment has taught you about remote working.
Um, First, probably we need to do this in many respects, regardless of the pandemic. Remote working, well, remote access to court. I still feel the judge needs to be in the courtroom with all the trappings. But remote access for parties, for litigants, is critical. It allows people to appear who can't afford to get there or don't have the transportation or are 120 miles from the courthouse. So it's critical that courts update and modernize and become an e-court, an electronic court, because we can provide that accessibility. We had to close a courthouse down in the southern part of our county for budgetary reasons some time ago. We still don't have the funds to build it and staff a new courthouse, but we've expanded our online access and allowing appearances electronically from the South. And we need to do that. At the same time, our courts have been built on hundreds of years of tradition, and we can't leave that tradition behind. When a person walks into a courtroom, they know they're walking into a courtroom. They see the judge in their regalia, whether it's a robe, a wig, whatnot. They see the court reporter, the court clerk, the bailiff. They see the formality, the counselors at law, the attorneys, and they respond to that. And it presents the dignity and the seriousness of the court. You don't have that online. You have pets in the background, you have children, you have neighbors screaming, you have sirens going by. So there truly is a place for access online. At the same time, we must build it accordingly and not leave the foundations of our justice system aside.
And finally, working in the pandemic has been a challenge for, I think, all of us. And of course, we're all differently positioned in terms of those challenges. So my last question is whether you have any advice, any judicial words of wisdom for those who are trying to manage these new ways of working.
Um, well, I got quite a bit from my nephew, Generation X, who has been working online for some time before the pandemic, and he just reminded me some time ago that it's work. Don't forget it's work. Get up in the morning at the regular time. Get dressed in appropriate work clothes. Have an appropriate work area. So just for work, you have to still remember it's work. Don't disengage yourself from the formality. Granted, we're all having bad hair days nowadays, but other than that, be prepared for court. When you're online, keep it formal. For a formal proceeding, keep it formal. The judge is setting the tone. And the informal meetings can be informal, but once you're in a formal hearing, set the tone. Expect all those appearing to be attired properly, to address the court properly. as a judge sets the tone in the courtroom, the judge must set the tone online. And as a judge is an expert or should be an expert on the law in the area they're working in, they also need to be an expert online. They need to know the technology. They need to show everyone that they're adept at the technology. They also need to have patience for those that are just signing on for the first time, to slowly walk them through the process, but to also expect the attorneys or litigants who are elderly or refuse to accept that, no, this is the process. Walk them through the process, help them through the process, have your patience, but maintain the proper decorum in the courtroom as you do online. It is work, and treat it as such.
Well, Judge Hood, thank you very much for joining us remotely at the Institute of Advanced Legal Studies. And finally, on behalf of our audience and myself, let me wish you all the best with your judicial ways of working. Thank you very much.
Thank you.